Hello, everyone. My name is Jane Talbot, and I'm the Vice President of the Downtown Vancouver Business Improvement Association. Welcome to the second session of our new weekly webinar series, BVBAA Members Helping Members. We're so glad you could join us online today. Now, if you joined us last week, you'll already know the technical aspects of how we manage our webinars. For those of you joining for the first time, I'll quickly walk through our process before we jump into today's content. You'll notice that all participants currently have their microphones on mute, so we ask that you submit your questions in writing today via the Q&A feature. To access the Q&A feature, you can hover your cursor over the main screen. If you're in full screen mode, you'll see chat, raise hands, and Q&A listed in the bottom of the image. Our presenter will be addressing your submitted questions after her presentation, so feel free to submit your questions whenever you'd like through the webinar. No need to wait until the presentation has concluded. And now, let's get into today's programming. Today's webinar is presented in partnership with Boughton Law and is called COVID-19 Employment Issues, Managing Your Rights and Responsibilities as an Employer. Leading our programming and answering your most pressing questions will be Boughton Law's Elizabeth Reed. Elizabeth leads Boughton Law's Employment and Labor Law Practice Group. She has represented clients at every level of court in British Columbia, as well as in proceedings before the BC Employment Standards Tribunal, the Workers' Compensation Board, and the Canadian Human Rights Commission. If you're wondering what kind of questions you can ask during our Q&A period, Elizabeth is routinely consulted for advice on topics such as termination packages, employment contracts, wrongful dismissal claims, and disciplinary measures, just to name a few. Thank you for being here today, Elizabeth. We're so glad you're willing to share your expertise with our members. And now, without further delay, I'll hand it over to Elizabeth to take us through her presentation. Take it away, Elizabeth.
All right, thank you everyone for having me here today. It's a pleasure to be with you. So there's a few topics we're going to look at. Essentially, we'll talk about some new legislation, and then we'll kind of work through changes that you might have to make in your workplaces in response to this COVID-19 crisis. And we'll sort of start with the least dramatic and then kind of move through to more intense changes. And then hopefully we'll end on a high note with some of the benefits that are available to your employees. I know for me it's been very just sort of reassuring as I've been working through this with a lot of my clients to see that one of their very first concerns is how is this going to impact my people and what supports are available for them. So we'll have a look at those things. As Jane mentioned, we will have time for questions afterwards. So the initial presentation will take about 30 minutes and then I'm happy to answer your questions. Now, I wouldn't be a very good lawyer if I didn't have a few disclaimers and some fine print. So these are the disclaimers. The first is that this presentation provides general information and it's not specific legal advice. So employment law is an extremely technical area of law, and there are lots of small facts that can make a big difference in terms of what legislation applies to an organization, what rights you might have under the common law, what obligations you might have under the common law. This isn't sort of a substitute for legal advice about a specific scenario, but hopefully will help you identify some of those pitfalls that are out there right now. The second disclaimer is that the focus will be on British Columbia law for provincially regulated employers. I do know from our guest list that there are a few people whose businesses will be regulated by the Canada Labour Code, so I have made a few notes so that I can highlight the differences where those come up. But for most of you, you're going to fall into this category. BC law will apply to you and you won't have to worry about the federal legislation. But because of that, keep in mind that every province has its very own employment standards legislation. So this presentation will not be super helpful for your cousin Bob who runs a business in Ontario, for example. They're going to have very different legislation. Lots of big principles will be the same, but everybody needs jurisdiction-specific advice. All right, the other final disclaimer is that this is current to today at about 11 a.m. As I'm sure you've all realized and seen, COVID is just creating incredibly quick changes at every level. For a while there, it seemed like there was new legislation being passed every day. That seems to have calmed down a little bit, but we still are seeing sort of subtleties and changes coming along fairly rapidly. So just keep that in mind. We're current up to today, but in a few weeks, there may be additional information that's needed. Okay, so I'm going to start with a brand new leave that we have here in British Columbia. Under our Employment Standards Act, there's been a new leave called COVID-19 leave. And essentially, we followed Ontario in putting this into place. And I think generally the concern or the sort of legislative purpose here was to make sure that employers weren't just kind of turfing people essentially because of reasons related to COVID-19. I think that was perhaps a little unfair. That is certainly not what I see with my clients, and I'm sure none of you do this sort of thing as well. Employer flexibility doesn't seem to be the biggest challenge through these times, but I think it was a concern. Certainly was a concern for the government right at the very beginning. They wanted to make sure that people weren't losing their jobs because they had to follow quarantine orders or other kinds of situations related to COVID. Of course, we're seeing now, the economic reasons are really the biggest drivers for terminations. But in the early days, I think they were concerned about just how are people going to respond to the virus generally. So that's where this has come from. We do have a very similar kind of leave under the Canada Labour Code with a few differences, but there is one under the Canada Labour Code, this kind of leave as well. So essentially, it's an unlimited leave for however long the situation demands, and there's specific situations in the BC legislation that kind of can apply. The employee is obliged to explain why they need the leave. They can't just say COVID-19 leave. They have to tell you exactly why they need the leave. You can't ask for a doctor's note. Not just are they not required, they're not actually even permitted, because obviously we didn't want to fill up the doctor's offices with people looking for notes right now. And the intention is that this will be removed from the Employment Standards Act following the pandemic. When I first started looking into this leave, I thought, well, maybe a month or two, a couple months. I think this particular legislation is probably going to be with us for quite a bit longer than that, but the intention is that eventually it will go away. The other interesting piece about this new leave is that it is actually retroactive, and it's retroactive to January 27th of 2020, which is the date of our very first coronavirus case, the first one that was documented. So that's why they've chosen that particular day. So who is it available to? Essentially, this is for people who have been either diagnosed with COVID-19 or people who are quarantined or in isolation. Now, it's not just a general, like, I'm afraid kind of isolation. It has to be an isolation that's due to an order of the provincial health officer, an order made under the Federal Quarantine Act, or because someone is following specific guidelines from the Centre for Disease Control or the Public Health Agency of Canada. And so you literally, to find out if someone qualifies for this, you are going to have to look at what those specific guidelines are, because sometimes the stuff that we see in the news is not entirely accurate. For example, right now, non-essential businesses are not required to be closed. They have to follow social distancing, but a lot of people think that they are not allowed to go to work, which is not necessarily the case. So the key thing is to kind of go back, figure out what the actual legal restrictions or guidelines are, and then go from there. Other people who can access this leave are if there are businesses that just can't meet the social distancing requirements or feel that their workplace causes too great an exposure to their employees and have said, we're going to shut down or we don't want you to come to work. Those people can take a COVID-19 leave from their employer. Also, of course, with the schools closed, there are an awful lot of people who suddenly don't have people to care for their children because the kids are going to be home all day. So if people need to provide care to their minor children, either generally or because of a school closure, those people are allowed to take a COVID-19 leave as well. The other big one is if there are still people who are stuck outside of British Columbia and they can't return to work because of travel or border restrictions, then those people are also allowed to take a COVID-19 leave. So the COVID-19 leave is a job protected leave. And so essentially what that means is that the employee gets to take the leave. It's essentially regardless of the time that they've been served with you, or that they've sort of been in service with you. You cannot punish them or terminate them for taking the leave. And they need to be returned to work in the same or a comparable position once the leave is over. So if your operations happen to be suspended when the leave is over, then you need to return the employees when those operations resume. And their employment is deemed to be continuous for any service-based entitlements. So this would count for things like if they were close to getting over a criteria to get a higher amount of vacation pay, or if they are later terminated, their employment sort of time served, any time that they were on leave is going to count for that time served. Now, another thing is that as long as the employee also pays their share of the benefit plans, employees do need to be kept on their benefit plans while they're on COVID-19 leave. So that's where one of the big differences kind of comes in with the COVID-19 leave under the Employment Standards Act versus federally regulated employers under the Canada Labour Code. Under the Canada Labour Code, it's much broader, the kind of leave. It's essentially if the employee is unable or unavailable for work for reasons related to the coronavirus. So not nearly as specific, pretty wide-ranging possibilities for interpretation there. So that will be interesting to see how that works out. Another major difference between the Canada Labour Code and the BC Employment Standards Act leaves is that under the Canada Labour Code, the maximum leave is currently 16 weeks, whereas it's unlimited in under the it's 16 weeks under the Canada Labour Code, and it's unlimited under the Employment Standards Act, and essentially just continues for as long as the situation demands. So that's the new leave. Now we'll kind of move into, what sorts of things are people needing to do in response to COVID-19 with their businesses, and what are your kind of options. So one of the options is looking at changes in compensation or hours. So essentially, changes in the terms and conditions of the workplace. It's very fact specific in terms of risk. So, and it's going to depend on what are your usual kind of common practices and terms of employment. So to give you an example, if you are in a common practice of changing your hours of operation, say, for example, in fluctuation with business demands, you probably have a bit more flexibility than a business that always works 9 to 5, Monday to Friday. So that's going to be pretty specific. But as a general rule, if you're looking at reductions in pay or reductions in hours of more than about 10 to 15%, then implementing those unilaterally could result in a constructive dismissal. And essentially what a constructive dismissal is when the employer has so changed the conditions of employment that it's really something different than what the employee signed up for. And in those circumstances, the courts won't expect the employees to necessarily put up with that kind of a change. So if you're looking at any substantial changes, it is always the best practice and puts you at the least risk if you get the employee's consent. If you don't, the risk is that you could end up with a wrongful dismissal lawsuit or a complaint under the BC Employment Standards Act. Now, right now, the courts are totally closed, but those complaint processes are available, when things kind of lighten up again, and the limitation periods are long enough that claims are still a risk once the world kind of gets back to normal. So you do have quite a bit of flexibility. So, you can work with your employees to find out what's going to work with your specific business. You could look at rotating shifts. You could look at reducing just every sort of the daily hours for your business. You could look at opening on alternate days. There's lots of possibilities out there, so you can be creative to look at what will reduce your payroll costs but still give your employees some income while you're working through this. And as long as you can get their agreement, then you should be in pretty good shape. One thing to kind of note is under the Employment Standards Act, there are certain changes that are deemed to be a layoff. So you do want to avoid those. The classic example is essentially a reduction in wages of more than 50%. If whatever you're doing results in that, then you are going to have a deemed layoff under the Employment Standards Act. So you want to make sure you don't do that. Essentially, the keys to kind of successful changes, making sure that the change is clear, that the employees understand how long it's going to be in place for. And it's okay to say it's going to be in place until, X date, and then we're going to review it, because I know there's a lot of uncertainty out there. But if you can at least give them some sense of when this is going to end, or at least when it's going to be reviewed, that's ideal. And you want it set out and consented to in writing by the employee. And sometimes people think that's a bit daunting, but I think you'll be amazed at the flexibility that most employees are demonstrating. People are understandably quite anxious that they won't have any work later, and most of them recognize that the employers are in very, very difficult positions as well, and everybody wants their businesses and the businesses that they work for to succeed in the long run. So you will see, I think, at least I've been seeing in my practice, a remarkable amount of flexibility amongst the employees when looking at what needs to be done to keep the business afloat. So our next kind of level of severity, I guess I would put it, in terms of looking at changes or responses to the COVID-19 crisis, is looking at temporary layoffs. A lot of businesses, of course, are just don't have revenues coming in, either because they've been forced to close or because nobody's spending their money anymore. All kinds of great businesses are really struggling right now, and that's totally understandable. So a lot of people are looking at temporary layoffs, and I know I've helped with a large number of them in the last few weeks. An important thing to know is that there isn't a general right to just lay people off temporarily. Again, it's a little bit fact specific in that there can be certain industries where general layoffs are quite common. And in those circumstances, it is considered a term of employment that the employees can be laid off at whatever time the employer needs due to a shortage of work. But for most businesses, that is not the case. And it's again going to be a bit fact specific. So, for example, casual employees, you don't generally have to worry about if they're true casual employees who you call them in when you need a little bit of extra support, maybe if somebody goes on vacation, but there's no kind of regular continuous employment, and the casual employee has the right to say, no, you know what, I don't feel like coming in, or I wanted to play with my grandkids, or whatever else they feel like doing that day. So casuals are one where, generally speaking, you can look at a temporary layoff or just not call them in. But again, it's very fact specific, and I have had occasionally clients say, oh, well, they're fine, they're casual. And when I've gotten into it a little bit more, I've heard, well, yeah, they're casual, but yeah, I know we called them in pretty much every day for the last 4 years. Okay, yeah, they're not a casual anymore. That's totally different. So it is going to be very fact specific. So assuming that most of you don't have that right in your employment contracts, because it certainly wouldn't be something standard. Most employees in the past would definitely have balked at an employment contract that said we can lay you off whenever we want for whatever reason at any time. So most people don't have them. So the key then is that the employee is going to have to agree to be laid off. And if they don't, then you are looking at a constructive dismissal under both Employment Standards Act legislation and the common law as well. So you need to get the employee's consent first. And that can be very confusing for people because under the Employment Standards Act, it refers to temporary layoffs. So people often think, oh, well, I must be able to just do it. But unfortunately, there is that common law background that informs the employment standards legislation and says, no, you have to get the employee's consent to that temporary layoff first. Again, most employees have been incredibly understanding and they get what's going on, and most of them will agree because they, particularly if they understand that the other option is, a permanent separation of employment. Now, there are very different rules under the Canada Labour Code for temporary layoffs. Under our BC Employment Standards Act, the maximum layoff right now is 13 weeks. Under the Canada Labour Code, you can have quite a bit longer layoff, but it depends on how the layoff is implemented and whether you have, for example, a specific time that you're going to call the employee back within, whether you have a supplemental unemployment benefit program, or whether you keep their benefits, their kind of regular health and welfare benefits going while they're on layoff. And in all of those circumstances, you can have, quite, really quite long leaves depending on which one of those you're going to do. So you have a lot more flexibility if you're under the Canada Labour Code, considerably less if you're under the Employment Standards Act. Now, a little bit of a caveat there, because up to today, at least, the maximum number of weeks under the Employment Standards Act for a layoff is 13 weeks. After that point, you are deemed to have terminated the employee if you haven't been able to call them back to work in that time. But we have seen a number of changes in other provinces. For example, Manitoba had a specific amount of leave in their employment standards legislation, and they have changed that to extend it to a considerably longer period. So we haven't heard any rumblings that that will happen in BC yet, but that may be coming. So keep your ears peeled for anything like that. Because obviously if that extends the period, that'll make quite a big difference for people. So something to think about. So in terms of actually looking at the layoff, again, the sort of keys to those temporary layoffs are that they're clear, that it's time bound in some way so that at least, the employee has a sense of how long they'll be off. And it should be set out and consented to in writing by the employees. And that last part is really crucial. The thing I'll say just briefly about the Employment Standards Act is it's always important to double check that your employees are covered by the Act, because not every employee is. There are a wide range of exceptions. So if you have, for example, employees who are not covered by the Employment Standards Act, then you don't have to worry about that 13-week deemed termination. So that's an important consideration is first figure out, are my employees covered by the Act? And then you'll have some of those, time bounds will become a little bit clearer after that. So an important thing to think about, any kind of temporary layoff, obviously that's going to have a big impact on your workforce, on your employees. But there's some pretty good research out there that says that, employees will understand if they have to be laid off. And the biggest thing that kind of impacts, your culture and how your business does going forward is how are those layoffs handled? Do the employees feel like they were cared for in the way that they were laid off? And do they feel like, someone was thinking about this and thinking about them as individuals and as people that were going to be impacted? That goes a long way to kind of helping your culture when you want to call them back afterwards. So a couple of practical considerations and some key documents that you need to look at. The first thing is, how are you going to tell the people who are being laid off? In previous times, we might have had like a company-wide meeting. Obviously now that's probably not going to happen. I do recommend that you try to contact the employees in person in some way, in the sense of a Zoom meeting or even just a telephone call, to speak to them personally when they're told that they're going to be laid off. And then you can follow it up with a sort of a document package that will explain the terms of the layoff. So you keep it kind of short and simple. When you make those calls, unfortunately, we're going to have to lay you off, but we have, we know you'll have questions, so we've put together a bit of a package, and we'll send that over to you later today by email for example. And that way you can kind of get through, even fairly large numbers of employees in a few days, and they can still get quite a bit of information, and you can still have a little bit of a personal touch with them. Another really important thing to think about is how are you going to tell the people who are left behind? Because they may have to take up some of the work that their colleagues have left behind, and they're going to have strong feelings about being left, really. I mean, they might be glad for their own jobs. They're probably going to be wondering if there are going to be further cuts to make. So that's a really important consideration is how are those who are left going to be told, and what are they going to be told to help reassure them. Another crucial thing is how are your stakeholders going to be told? Because of course your employees are working with a wide variety of people probably every day. So they might have suppliers that they work with regularly. They might have clients. They might help support your board. Your shareholders maybe, if they're active shareholders, may need to be informed. So thinking about who's going to be impacted is really important, and having a communication plan in advance for how those people are going to be let know, so that they don't try to call someone and go, oh, wait a minute, like, where's that person, what happened there, how come they're not there. If they know there's a plan in place, it just gives everybody a sense that the business is on top of it, they know what they're doing. Think about how you're going to manage the transition of work. Look at whether the employees are going to have access to keys, security passes, IT infrastructure, property, that kind of stuff. That's going to be very business specific. In some businesses, depending on your workforce, it might be totally fine to let everyone keep all those things. In other businesses, or if you have a large number of employees, you might have to get that stuff back while people are on temporary layoff. And another thing is to consider how are you going to try to keep connected with the people who have been laid off. So, particularly in a temporary layoff situation, these are people that you're hoping will come back to work for you, and you want to make them feel that even though they have been laid off, they're still valued members of the team. This is temporary, and you do hope to get them back as soon as possible. So keeping in touch with them in some way, whether it be like a little company newsletter or a phone call every now and then from their manager just to see how they're doing, those things will go a long way to let them know they haven't been forgotten while they're on layoff. A couple of key documents there. You do want to have a temporary layoff letter that the employee can sign and acknowledge and accept their temporary layoff, and obviously records of employment that will help them apply for their benefits. Although a key thing there is they don't actually have to wait for the record of employment to apply. They can apply for the benefits, and then the Service Canada people will match them up with their social insurance number when their ROE comes in. So you can tell them they don't have to wait if they're going to be applying for government benefits. They should just go ahead even if they don't have their ROE yet. So those are some of the practical considerations for temporary layoffs. I think those are kind of best case scenario for a lot of businesses. Unfortunately, even with other measures that people might be taking, a number of businesses, I'm sure, will have to look at permanent reductions in staff. These are unprecedented times, but unfortunately, that's just the reality. Notice is still going to be required. So even in this difficult time, even when employers are really seeing, a cash flow crunch, if you don't give notice, then you are going to be at risk of a wrongful dismissal lawsuit or a complaint under the Employment Standards Act, or possibly the Canada Labour Code if you're laying off due to a shortage of work under the code. Now, the amount of notice, that's what everyone always wants to ask is, well, how much am I supposed to give them? And there's basically three places that we look when we're looking at how much notice do we need to give an employee. The easy ones are the Employment Standards Act and the Canada Labour Code. Those are very clear, set out based on just your years of service. Under the Employment Standards Act, it varies a little bit in the first few years of employment, but after 3 years, it's, a week per year of service up to a maximum of 8 weeks. Under the Canada Labour Code, there's both notice of 2 weeks or 2 weeks pay in lieu of notice, plus a severance package, and that varies again on how long the employee has been with you. But in most cases, the employment standards legislation is going to be relatively small compared to what we call common law notice. And the common law notice applies if you either don't have a written employment contract with your employees, or you have a written employment contract that either doesn't deal with termination or doesn't deal with termination properly. And I see an awful lot of those, unfortunately. So in those circumstances, you are going to be reverting to what we call common law notice. And that's the one that's a lot more challenging to determine because it does vary depending on the employee. And the courts love to take into consideration what they call all of the factors. And so, as you can imagine, there can be some pretty big disputes about what factors are relevant, how those factors apply in a particular case. Um, the general consensus, there are kind of four big ones that we look at. We look at the availability of similar employment. We look at the nature of the person's position. We look at their age, and we look at their years of service. And so the older they are, the more notice, particularly once they get into sort of close to retirement age, the more notice they're going to get. The longer their service with you is, the more notice they're going to get. If they have a really specific kind of job, like they make this specific widget that can only be made at 3 different companies in the entire world, they're going to get way more notice than somebody who has a much more generalized skill set. And they'll look at the nature of the employment. So is this somebody who's doing an administrative or clerical position? Are they somebody at a senior executive level? Generally speaking, the senior executives are going to get more notice, although I'll give you a little bit of a caveat there. The courts are taking a little bit more egalitarian view of those things in sort of the recent, I'd say the last 5 years, and kind of questioning, well, why should a CEO get way more notice than somebody who's working at their local Starbucks? So that one's becoming a little bit less of a factor, but the first 3 are kind of the really big ones. So essentially that, and the key thing about the common law notice is just that it is so much more than the employment standards notice. So the maximum notice under the Employment Standards Act is only 8 weeks. If you have somebody in a very senior position who's been with you for 24, 25, 30 years, you could be looking at 2 years worth of notice. So that's a huge difference, and something that you want to be really careful of and make sure you get right if you're looking at terminating someone with a lot of service. Now, the thing about notice under our common law is that it's an implied term. Essentially what happens is the notice period is an implied term that the judges kind of put into every employment contract. And the specific implied term is that you're supposed to give the notice in advance. So essentially, if I were telling Jane, I'm sorry, Jane, I can't keep you working for me anymore. You're going to be done. Say Jane's been with me. She's getting close to retirement. She's been with me for 30 years. You're going to be done in 2 years. Well, you can imagine how motivated Jane is going to feel knowing that she's headed out the door. So most of the time, what we actually do is we technically are breaking the employment contract. We're breaching the employment contract. And instead of giving Jane 24 months notice in advance, I negotiate a severance package with her instead. And so what the courts will do is they'll look at what would Jane have earned during that 24-month notice period. And the really important piece there is that if Jane can find another job fairly quickly, then essentially she's not going to have a lot of damages. So it's a bit like a no harm, no foul kind of situation. Because Jane might have been entitled to 24 months notice, but if 3 months later she finds a fantastic job that pays her just as well, just as much as what I was paying for her, even though I breached the contract, she actually hasn't suffered any damages or not any significant damages as a result. So my liability is going to be limited to just those 3 months when she wasn't employed. So essentially, when we're looking at severance packages for employees under the common law, we're basically trying to crystal ball gaze. And we're trying to figure out, okay, what's sort of a fair amount to offer, given the possibility that they could find a job quite quickly and we'd end up paying too much, or they might not be able to find a job for a very long time and we might have paid far too little. So those are the kind of competing things that you're trying to balance when you're looking at what it might be a proper severance package for an employee of that nature. So that's the common law. The other place that we look is, of course, an employment contract. And this is essentially where, if you have a good contract in place, you've implemented it properly, that is going to save you a ton of money and a lot of time and a lot of legal fees as well, because you will have negotiated with the employee in advance about exactly how much they are supposed to get in a termination situation. So that's fabulous because usually then you can limit it. Everybody's kind of agreed, and they've agreed at the beginning when they're all happy with each other and people are getting along. They've said, this is what we think is fair. And then all you have to do is go to your contract as long as it's enforceable language and it was implemented properly. That's all you need to give the employee, and then you're in pretty good shape. So those are the kinds of things that go into that consideration for how much notice do you have to give for an employee. Obviously, the kind of fewer layoffs you're doing, the more tailored it can be to specific situations. If you're looking at a large number of people, then sometimes we'll look at categories for clients, and we'll say, okay, sort of, so for people in sort of this range of service, these kinds of positions with between these ages, this is what they should get, and it's a little bit more of a rough calculation. And then if it's just one or two people, then we can do quite a detailed analysis if that's appropriate for that situation. So there we go. That's everything you wanted to know about notice in a few minutes. Do keep in mind when you're looking at permanent reductions in staff, there can be personal liability for directors and officers for any amounts owed under the Employment Standards Act. So that includes termination pay, and it can be up to 2 months' wages. So that can be a lot of money. So you don't want to be personally liable. It's not just people who are directors and officers under the under your corporate records. It does include senior executives. So there can be some risk there. So it's really important if you're doing permanent reductions to get those right. And generally speaking, one way to know if you're going to have a problem in the future, of course, is when you offer the severance package. If you offer people a little bit extra, you offer them something under their common law rights in exchange for a release, then you'll know pretty quickly whether you're going to have a problem or whether they're prepared to sign off on something or not. And most of the time, those things will be negotiated if someone does come back to you. So doesn't necessarily mean you're off to court right away. Generally, we can work these things out, but it will give you that peace of mind if you can get a release from the employee, because you won't have to worry about it going forward. Another important thing if you're looking at permanent reductions is looking at benefits, because when we look at things like benefits, because if we go back to that analysis, we're looking at all the things the employee would have had during their employment. So if that includes a benefit package that might cover them for, say, short-term disability or long-term disability, and the employee ends up getting sick and doesn't have those benefits, the case law in Canada is such that if you have not provided the benefits and you don't have a release, then you could be on the hook not just for the premiums that you would have paid to the insurance company, but for those actual benefits that the insurance company would have provided. So if you end up with someone, to use the COVID example, you terminate somebody who was entitled to common law notice, they get sick with COVID, they have severe damage to their lungs, and they can't work for the rest of their lives, and they had benefits that might have covered them to age 65, you could be on the hook, your business could be on the hook for those benefits. So really important to try to minimize any time that the employee is not covered, essentially, or at least minimize the time that you might be responsible for it. So that means either trying to continue the coverage, providing the employee with some pay so that they can get their private coverage, or getting a release from them and essentially letting them know that they're responsible for figuring it out on their own. So that's a really important thing to think about, particularly in these pandemic times. Now, there are some exemptions to notice requirements. So there can be specific industries that are exempt. For example, construction industry is a common one. Those casual employees, again, are a common one that we see. So do consider those. if you've been forced to close by an order of the health officer and you will not be reopening, and that's sort of the key part, is you might consider what we call frustration of contract, and some of the related sections in the Employment Standards Act that deal with that. In certain very, very limited circumstances, you may not have a requirement to give notice if the COVID-19 crisis has completely frustrated your employment contracts. Now, how that's going to be, how that particular doctrine of frustration is going to be applied in COVID times is not known yet. We have seen some previous cases, for example, where an entire building burnt down, and the whole business was essentially destroyed, but because the first thought would be, well, that should be clearly frustration of contract. It's a third thing that comes in. It's nobody's fault. No one could control that. But because everyone was very clear right from the beginning that the business was going to be rebuilt, the building was going to be reopened, they found that that was not a frustration of contract for those employees, and they were entitled to come back to their jobs. And if they were not brought back, then it was a termination. So very interesting to see how those cases kind of play out, but something to think about, whether you won't need to take that position if you know for sure that you're not going to reopen. And it's not just due to the economic circumstances. It would have to be due to something like an order from the health officer that you close. So that's all the sort of what I would describe as the dire side of the news. I'll just run quickly through some benefits because I note the time. Government benefits for employees are changing really rapidly. Key benefits right now are the Canada Emergency Benefit, employment insurance, and the BC Emergency Benefit for workers. There are many other benefits, but they're much smaller and have stricter eligibility requirements, so I won't look at those at all in any detail. The CERB, you probably heard quite a bit about that. I've sort of summarized some of the general eligibility requirements there. Key criteria are that you've stopped work or have had reduced your income to less than $1,000 a month because of COVID-19. If you're sick, you're quarantined, or if you're taking care of someone else with COVID-19, or you have to stay home to care for your children. And that benefit is $2,000 a month for up to 4 months. You can make your application online or over the phone. Applications dates are based on your birth date, so you have certain days of the week that you can apply depending on when you were born. It's going to be offered between March 15th and October 3rd. And it is a taxable benefit, so but the tax is not being deducted at the source, which I think is going to be a rude awakening to a lot of employees who receive the benefit, because they're not going to. I think they're just going to forget, or they may not be able to put that money aside. So they're going to get a bit of a rude awakening at tax time, but it is a taxable benefit, so that money should be put away if people can. The overlap with EI, you can't get EI and the CERB at the same time. There's a bit of a weirdness going on in that if you have an EI claim after March 15th, you're automatically going to be processed through the CERB, and they're still sort of sorting out what all the ramifications of that are, for example, on supplementary unemployment benefit plans, things like that. I've been on the phone with the Deputy Minister of Employment's Chief of Staff, harassing her weekly, going, what's going on with this? What are you guys going to do? And she says, well, it's on our list of things to worry about. So they are trying to figure out what all those ramifications are, because they're flowing all the EI benefits through the CERB first. The other benefit, and the last one I'll talk about just briefly, is the NDP did announce this BC emergency benefit for workers. That's a one-time tax-free payment of $1,000. To date, we don't have any information on kind of eligibility requirements or how to apply. I was looking at it again yesterday, and I didn't see any updated information, but it looks like it will be tied to the federal CERB program. So we can look forward to more information or on that, hopefully in the weeks to come, about when that might be paid and who's going to be eligible for that particular benefit. So there we go. I think anything else? Yeah, that was it in terms of specific things that I wanted to make sure that we covered. I'm very happy to answer questions if there are questions out there. So just let me know, and away we go.
Fantastic. Thank you. That is incredible, Elizabeth. So we have 3 questions, and we have about just about the right amount of time. So as with any other company, our team is fully working from home during this time. What is the employer's obligation regarding WorkSafe BC? If an employee is injured at home, are they covered by WorkSafe BC?
Okay, that's a great question. There definitely are WorkSafe BC obligations that continue even though the employees are working from home. I think that might surprise a lot of people, but your regular WCB rules actually apply when people are working from home. At a minimum, WBCB has said that you have to conduct a safety assessment. I mean, this sounds a little bit crazy. And I think when people first went out and there was sort of a mass exodus to work from home, I must confess, when I saw it on the website, I sort of thought, oh man, bigger fish to fry. But it is important, and it's very clear that people are not going to be just working from home for a very short period. So we do have to start thinking about the ergonomics and safety risks. So ideally, you would have a little safety checklist so that the employees could look at their workspace at home and make sure that they don't have any frayed cables in their home office or their kitchen table, and they have dealt with any trip hazards. And those are the kinds of things that WCB is usually looking at. And if you can say we've kind of gone through those risks with our employees and they've taken some steps and we've directed them on how to deal with those, then that will help a long way to avoiding any WCB sort of claims of non-compliance. You are supposed to look at reporting procedures if there is an incident at home. The question of whether it's going to be something that's covered by WCB if it happens at home is going to be fascinating, and that's going to be really fact driven. Where was the employee at the time? They might be working from home, but if they are getting a back strain because they're doing their laundry because all the kids are at home and whatever else is happening, obviously there's going to be a lot of factual investigation that WCB is going to have to go through to be satisfied that it was truly a workplace injury. So that'll be very interesting. Another thing that people often don't think about in terms of WCB is there are actually lone worker monitoring requirements. So if you have somebody who's single, who's working at home all day, and they don't have any other people that they're coming into contact with, you actually have an obligation to check in with them and put in place a lone worker monitoring program. If they have other people around, like a family member who's also working from home, then it's as long as there's somebody who could kind of help, then that's not going to apply. But if you've got a lot of people who are working from home alone, or if their partner is still going into work at another location and they're going to be alone because of that, then you actually do need, under the legislation, a lone worker monitoring program. So those are some of those ongoing obligations.
Yeah, that'll be interesting to keep our eye on that one for sure. So next question, when this is over, what's our obligation to the entire company, the people and the physical environment? If an employee is infected with COVID-19 after we return to the office, what do we do?
Okay, well, I mean, if you have someone who's been infected, obviously that person needs to go home right away if they were in the office, and they should be granted a COVID-19 leave while they're recovering. I would recommend that you do a bit of some contact tracing within the office to figure out, who they might have been exposed to. And depending on the results of that investigation, you may have to ask other people to work from home while they self-monitor any symptoms for 14 days. While they're after that potential exposure. That's probably the safest practice. And then in terms of the actual office itself, there is certainly some evidence that the COVID-19 virus can live for at least a few days on metal surfaces and on plastic. So I think a good deep clean of any places in the office that employee might have gone would go a long way to kind of meeting your requirements to keep the rest of your team safe.
Okay, thank you. So next question. Let's see, as with many other companies, our team is fully working from home during this time. I think you spoke to this a bit, but what's the employer's obligation regarding WorkSafe BC if someone is injured at home?
Yeah, that's going to depend on what was the nature of the injury and what were they doing at the time of the injury.
Right.
So yeah, so if it's workplace related and I think as a practical matter, that's where it's going to get really interesting, is how do you prove that? Particularly given that there may not be anyone there with them when it happens. Um, yeah, I think we'll see some very interesting litigation coming out of that.
Right. And to your knowledge, are there any WorkSafe BC home walkthroughs that people can do to make sure that their homes are safe and ready for the employee to work from home?
Yes, WorkSafe BC does have a little kind of checklist about working from home. It's not exactly a checklist, but sort of at least an outline of things that employees can or employers can ask their employees to look at. So I would suggest that have a look on the WorkSafe BC website, and if you Google, working from home or telework, that'll come up fairly readily.
Okay. One more question. We have no plans to lay off employees. How should we address it if one of our employees would prefer to be laid off instead of continuing in their role?
Well, if the employee would prefer to be laid off, then I think the it depends on why they want to be laid off. But generally speaking, an employee doesn't have a right to be laid off. So it's going to depend. Yeah, I mean, we could get into some interesting discussions about, is it a refusal to work because of fears of COVID-19? That has sort of different implications than, for example, if the person wants to be laid off because, they've got kids at home, they're finding it impossible to work from home, and they'd rather collect the $2,000 CERB from the government than actually have to go to work for 4 months. That's quite a different scenario. So if it looks like it's being motivated by those latter concerns, you don't want to be participating in what is essentially, government benefit fraud. So I wouldn't recommend that if people want to be laid off, I would really want to dig into why.
Right.
What's the reason that they want to be laid off? I think that would be my concern there.
I think we have time for, let's take two more questions. And here we go. What can I do if an employee says they are sick, spends 14 days at home, and does not want to return to work out of fear, simply out of fear after 14 days? So they should be able to come back. There's no reason why they couldn't come back, but they're afraid to come back.
Right. Well, and that's a challenging one, because if the employee frames it as a refusal to work, in the sense of under the Workers' Compensation Act, employees do have a right to refuse unsafe work, and there's a whole process that they have to go through. So they have to put it in writing. They have to put exactly why they don't want to come in, and if they say, if that seems to be related to a hazard at work, then there's a whole WCB process, that you have to investigate the issue, and then if you can't resolve it and you can't convince the employee to come back, then you have to call, the WorkSafe BC office and get a prevention officer in to look at it. So it goes through a whole kind of rigmarole there. If it's not based on anything specific in the workplace and it's literally just, I feel too scared to leave my house, that's not really a valid reason to stay home from work. So you would be looking at that as, potentially a disciplinary issue. Now, for a lot of employees right now, you might decide to look at it, the other thing is that it depends on the severity of the concern. So for example, if the person has developed like a full-on like anxiety disorder or a depressive disorder or some kind of mental health condition that's literally stopping them from feeling comfortable to work, I think in those circumstances it would be quite appropriate to grant them a COVID-19 leave or a leave for medical reasons, until that anxiety and is dealt with. But if it's just literally like, no, I'm too scared, but it's not something that's documented as a medical condition, then I would treat it as a disciplinary issue. You'd have to say, look, after you're well, we understand that you're well now. We've put in place all these safety protocols. Our expectation is that you'll come back to work. And if you're not going to come back to work, that has disciplinary ramifications.
Okay. Final question. Is CERB only applicable to people who have completely stopped working, or does an employee with reduced hours still become eligible? There seems to be conflicting information from media reports and the government websites.
So sorry, I missed the first part of that question. I think it was, can people be working somewhat at this time for the CERB? Was that the question?
Yeah, is CERB applicable to people who have completely stopped working, or does an employee with reduced hours also apply?
So you're probably seeing conflicting information because it has changed. Because originally under the CERB, there was you had to completely stop working. You couldn't have any hours or expectation of work during the period that you were going to be receiving the CERB. But that has quite recently changed, like within the last week. So now people who are, as long as you're earning less than $1,000 a month, then you could still qualify for the CERB. So you can still have some part-time hours, but if they've been reduced because of COVID, then you still can apply for the CERB. That's at least the latest on the website this morning.
Okay. Well, that is all we have time for today. Thank you, Elizabeth, for all the great content and for answering our questions so thoroughly.
It was my pleasure. It was great to have everyone there. I wish I could see your shining faces.
To our participants, you'll be receiving a follow-up survey via email this afternoon. And we appreciate hearing from you. We hope that you'll find a few moments to fill out the survey and let us know how we did today. As well, we'll be doing these webinars weekly for the next little while. And if there are topics that you would like for us to explore, please let us know. Please email us and let us know. And finally, one last thank you again to Elizabeth for all the great content. And we really, really appreciate your time. Finally, a huge thank you to Boughton Law for collaborating with us on this project. Your support is, as always, so important to us. That's it for today. Thanks, everyone, and we'll see you next week.